Hi everybody, this is Arcady Frekhtman. I'm a New York City personal injury trial attorney, and today we are looking at verdicts and settlements in New York for construction accidents, also known as the labor law, where a construction worker gets hurt on the job either by falling from a height, such as from a ladder or scaffold, or when an object falls and injures the worker. And we're looking at the 10 most recent verdicts. And I'm gonna have you try to guess the verdict. So I'll tell you about the case, and then at the end, I'll do a little, and I'll tell you the verdict, but you'll have time to see what you think the case is worth. So let's get into it. Here's the most recent one according to one of these databases, and this one is Westlaw. And so the most recent one is from November of 2023, and it was a verdict. So it went to a jury, and the jury decided the case. And this was a case where the incident happened back in April of 2014, and the lawsuit was filed in May of 2014, so just a month later, but the trial didn't happen until 2023, so almost 9 years later, almost 10 years later. And this one happened in the Bronx. So what happened was a worker, a 53-year-old male construction worker, was working at a construction site, and the defendant was the general contractor and owner of the property. And while he was working at an elevated platform, he was hit on the head by a brick. He lost consciousness and he fell to the ground. And the plaintiff reported injuries, including traumatic brain injury, which included occipital neuralgia, daily headaches, dizziness, spinal cord injury, cervical disc herniations, leading to spinal radiculopathy, requiring a C4, C6 discectomy and fusion. So that's a surgery, and that's C4 to C6. So it goes C4 to C5 and then C5 to C6. So that's a 2-level neck fusion. That's pretty serious. He also had lumbar disc herniations and bulging, leading to spinal radiculopathy and requiring a spinal fusion surgery in the lower back. Now, it doesn't say what levels, but that's also very, very serious. And he had bilateral tinnitus and hearing loss and a skull fracture. And he claimed he was unable to return to work and sustained a quality of life loss. And according to the plaintiff, the defendant failed to provide him with a safe place to work, reasonably free of dangers and hazards, failed to provide proper and safe elevated working surfaces, scaffolds, ladders, failed to provide the plaintiff with approved safety devices, and violated the applicable provisions of the New York labor law, the industrial code of the state of New York, and the Occupational Safety and Health Administration, known as OSHA, as they apply to construction work. And the defendant disputed causation regarding the plaintiff's claimed injuries, presenting expert testimony that gave the opinion that the plaintiff did not sustain an intracranial injury, and argued that any radiculopathy or radiating pain, as well as myelopathy, which is spinal cord compression, were not related to this incident. And so this was the Bronx, right? So this was a jury trial. And like I said, it was towards the end, around Thanksgiving, the end of November 2023, just a few months ago. And so the verdict was, can you guess the verdict? Okay, the verdict was a total of $4,881,000. And it was broken down as follows. It was pain and suffering was $4 million. I guess that includes past and future, past from the date of the incident up until the trial, which was almost 10 years, a decade, and then future being from the date of the trial for the rest of his life. He was 53, so he would still have 30 years approximately, according to the pattern jury instruction averages for life expectancy. So he would still have 30 future years, so that would be significant. Now, future medicals were $621,000. Past wages were $260,000. And so the total amount was $4,881,000. So a pretty good result for the plaintiff. I mean, 5 million, almost 5 million, pretty good result. Okay, let's go to the next case. Here's a case, this one's in Brooklyn, and this one was the month before, October of 2023. And this incident was filed in 2018. And the date of incident was 2017, July 10th of 2017. And it was filed January 8th of 2018. And the verdict was in October of 2023. And like I said, this was in Brooklyn, which is Kings County. And here what happened was the plaintiff was performing construction, renovation, demolition, painting. I guess, you know, I don't think he was performing all of that. I think what they're doing here is they're just talking about the statute, right? Because the statute, meaning the labor law, protects construction, renovation, demolition, painting, and or repair work. But I don't think one person was doing all that at once, right? So I think, you know, it's probably just not a very in-depth summary. They're probably just mimicking the words of the statute. But yeah, that's what it says. And he was doing it at a premises owned and maintained by defendant's City of New York, the New York City Department of Education, and the New York City School Construction Authority. And the construction worker said he was working on a scaffold when he was struck by falling construction materials. And he reportedly fell onto a platform 2 to 3 feet below where he was working. So not a huge fall, you know, 2 to 3 feet is not a huge fall. And he suffered injuries to his back and left knee. His spouse, who was also a plaintiff, said she suffered loss of services. Now, the plaintiffs asserted negligence in failing to provide the construction worker with a safe place to work, including proper safety devices, and they asserted violations of the labor law, Section 200, 240, and 241.6, as well as Rule 23 of the Industrial Code of the State of New York. So again, they're just mimicking the statute. I mean, everybody who has a fall, almost everybody's going to assert these provisions. That's the provision. So they're not really telling you too much about what happened or what the specific losses were. They're not even really saying what the injuries were, aside from back and left knee. So I guess in order to really do a deeper dive into this case, you would need to go on either NYSIF or ELAW and pull the actual documents. Then you could see the bill of particulars and you could maybe look into what the actual injuries were. So this is going to be a tough one to guess, you know, because there's not much information here. I guess this isn't a very good write-up, but let's try it. It was before judge. Oh, I know this judge. I've actually tried 2 cases in front of this judge. He's a pretty good judge. So let's see what they say. The verdict in this case was, let's see if you can guess it. It was $2,259,117. And it was broken down as follows. It was $500,000 to the plaintiff for the past pain and suffering, $214,000 to the plaintiff for past lost wages, $43,000 to the plaintiff for past loss of annuity benefits, $98,000 to the plaintiff for past medical expenses, $200,000 to the plaintiff for future pain and suffering for 10 years, $182,000 to the plaintiff for future lost earnings for 25 years, $272,000 to the plaintiff for future loss of annuity benefits for 25 years, $381,000 to the plaintiff for future loss of pension benefits for 25 years, $216,000 to the plaintiff for future medical expenses for 38 years, $100,000 to the plaintiff's wife for the past loss of services, and $50,000 to the plaintiff's wife for future loss of services for 10 years. So altogether, it was $2.2 million. And the plaintiff did have an expert. He used an expert on construction safety. So that's the second case. And, you know, it's just like I said, there's just not enough information to really get into the nitty-gritty, but it gives you some information. Let's go to the third case. The third case was also in October of 2023, and this case was in Long Island, in Nassau County, a more conservative venue. This case, the date of incident was June of 2018. It was filed in September of 2018, and the verdict came down in October of 2023. So a little quicker in Brooklyn. You see like 2018, and you figure with COVID, but you got like that's a total of what, about 5 years, right? Because you got 2 years to get to 2020 and another 3 years. So yeah, about 5 years. But the other case in the Bronx was almost 10 years, so it's much slower. And here, the plaintiff said he fell when a wooden deck collapsed while he was working at a residential construction site on property owned, controlled, and maintained by the defendant, who was an individual. The plaintiff asserted the defendant was also the general contractor for the site and supervised, managed, inspected, and directed the work being performed at the site. The plaintiff allegedly suffered injuries to both of his knees and legs. He asserted claims of negligence and violations of sections 200, 240, 241 of the labor law and the rules of the Board of Standards and Appeals and the rules and regulations of OSHA for failing to provide him with a safe place to work. The plaintiff's allegations included that the defendant failed to keep the premises safe by permitting the deck to remain in an unsafe condition, failed to use the methods and customs commonly employed to prevent the accident, failed to use reasonable care in the supervision and control of the premises and or work being performed, and failed to warn of the dangerous condition of which the defendant knew or should have known. Now, I'll tell you a little bit about this just for my own knowledge. When you sue an individual like that and you're doing work on a one-family house, you can't really sue under Section 240 or 241 unless that individual who's the owner directed and controlled the work themselves, right? If you're just an owner of a house and you hire a construction company and one of the workers gets hurt, they can't sue you as the owner of the house, right? That's an exception to the labor law. So that makes the case a lot harder. A lot of lawyers don't even take these cases. They want cases against commercial construction where you're building a commercial enterprise, right? Like a skyscraper, and you don't want to sue single family homeowners because of that exception. Because proving that they directed and controlled the work is hard. It means that they were the general contractor, they were on the job site, they were telling the workers what to do, they were directing and actively controlling the work site. And if they weren't, right, if they just said, hey, build me a house, I'm just gonna, live somewhere else, I'm not gonna be there every day, I'm not gonna tell you what to do, well, now you're out of luck, right? That's the exception to the labor law and you can't sue them. So given that, let's see what happened in this case. The verdict, can you guess the verdict? The verdict in this case was 0. It was for the defendant. So I guess the jury did not think that this particular homeowner directed and controlled the work. There wasn't enough proof. And so that could have been, it doesn't say why the verdict was 0, it just says the verdict was 0. But yeah, probably that was what it was, because that is the rule. So yeah, it makes it tougher, makes it a lot tougher for the injured plaintiff. Okay, the fourth case. The fourth case was out in Long Island as well, but this one is in Suffolk County. That's further out east. And this was a case that the date of incident was February 14th of 2019. The date of filing was March of 2019. And the date of the trial, or the result, was October 3rd of 2023. And I'll tell you a little bit of a side note on this case. I believe, yeah, I know some of the lawyers that were trying this case. In fact, I was at a legal conference in September while the case was on trial, and I actually talked to the main lawyer that was trying the case. I think his firm was trying the case, but he had someone else trying it for him, and he told me about the case, and he was real confident about the case. He thought it was a really strong case. I think this is probably the same case, because according to what he told me, it sounds like it's the same case. But let's see, what is this case all about? So here you have also a 53-year-old laborer, and he reportedly fell 14 feet from an extension ladder to the floor at a work site that was owned and managed by defendants. And now the defendants are a real estate management LLC, as well as a company, and some kind of sports company. And so the plaintiff reportedly was doing spackling work when he fell, hitting his head. The plaintiff allegedly sustained a concussion with loss of consciousness, post-concussion syndrome, a traumatic brain injury associated with a contusion, subdural hematoma, and subarachnoid hemorrhage, and a non-displaced fracture of the posterior parietal bone. The plaintiff also underwent an anterior cervical discectomy and arthrodesis fusion at the C6, C7 with the insertion of an intervertebral implant. The plaintiff asserted the defendants were negligent in violating the labor law, 200, 240, and the New York State Industrial Code. The defendants contended the accident stemmed not from a failure or defect in the ladder, but in the manner in which the plaintiff was using the ladder, because the plaintiff was attempting to spackle while standing on the fourth rung from the top, while the ladder's feet rested on debris on the floor. So they were saying it's the plaintiff's fault. You put it on debris, it's uneven, and now you're on the fourth rung really high trying to spackle, like leaning, and usually it's not a defense to the labor law, because the labor law says the defendants, right, the general contractor and the owner of the job site, have a non-delegable duty to provide the construction worker with a safe place to work. So usually it's not a defense unless the plaintiff is what's known as a recalcitrant worker, where they say, here's the safety device. And he says, you know what? No, I don't want the safety device. Like, here's the hard hat, wear this. No, I don't want to wear it. Well, then, he's choosing not to wear it. That's different. But I don't think that they're arguing this here. And the plaintiff moved for summary judgment on the issue of Labor Law 240, subsection 1, which was the elevation-related statute, right? The elevation meaning the gravity. And the court granted the plaintiff's motion. So now liability is done, right? The summary judgment is granted for the plaintiff, meaning the plaintiff wins on the issue of liability. Now, the only question is the damages. So you have this traumatic brain injury, you have this anterior cervical discectomy and fusion, you have serious injuries. So what do you guys think? What is the verdict in this case? What do you think they got? The verdict was a total verdict of $1,065,000. So something, $1 million, but not an amazing verdict, not as high as probably it should have been or it could have been. And I'm thinking because it's Suffolk County, because the lawyers who tried it are pretty good lawyers. And, I'm thinking it's because it's Suffolk County. It's a very conservative place. And it just says that the compensatory award for pain and suffering was $1,065,000. It doesn't break down like it did in the other videos of how much for each, category. It just says $1,065,000. Okay, let's get into the next case. The fifth case. See how many we could do. The fifth case is a case from Westchester, another conservative venue. And here what you have is a 41-year-old plaintiff who was working at a construction project located at a property owned by the defendant LLC owner and maintained by the defendant as a bakery, a company, where shipping containers were being converted into storage space. The plaintiff allegedly was applying contact glue cement to the flooring of the container. The plaintiff said the glue was highly flammable. The container was enclosed and unventilated or inadequately ventilated, and an explosion and fire occurred. The plaintiff reportedly suffered second and third degree burns to his face, neck, ears, hands, lips, and underwent surgical debridement and suffered scarring and hyperpigmentation. Oh, that's really serious. That's terrible. Burn cases are, some of the worst cases in terms of the injury. The plaintiff asserted negligence in failing to provide him with a safe place to work, allowing him to be exposed to a hazardous chemical, failing to provide adequate ventilation, and failing to provide him with proper safety devices. He also asserted violation of the labor law, sections 200 and 241(6), and Rule 23 of the Industrial Code of the State of New York. The defendants argued that the ventilation system in the container was operating in the days before the incident. They claimed that the plaintiff did not ask for a different type of cement to perform the work and disobeyed directions to wear protective gear, including a hard hat, goggles, gloves, though he was provided such gear. So that goes to the recalcitrant worker, right, that we just talked about. Basically, if you say, hey, here's the equipment, and you say, I don't want it, well, then you can't blame the owner or the general contractor. Now it's the plaintiff's fault. And the defendants also argued that one of the companies was an out-of-possession landlord. So there's case law on that. If you're an out-of-possession landlord, you just own the building, but you don't actually possess it, and you don't have any, requirement to maintain it or to to do anything to manage it because you just own it and you completely rented it out to other people. So you could be somewhere else, right? You could be anywhere. You could be in Florida, you could be in China, anywhere, right? You just own this property, but you've given control of the property to someone else, whoever the tenant is, and the tenant is 100% liable. There is case law on that in New York that protects the worker unless they have a right to come back in and left a right in the lease or have some kind of right of reentry and assume some kind of duty to manage it. Because if they really truly are out of possession, then they could be out of the case on that ground. So let's see what happened. What do you guys think happened in this case? Westchester venue, these injuries, like we talked about, the third-degree burns to the face, neck, ears, hands, lips, surgical debridement, and scarring and hyperpigmentation. 41-year-old plaintiff. So the verdict was, it was $4,150,000. And it was a compensatory pain and suffering verdict. Doesn't say how it was broken down, but this was Westchester. And I don't know if I said, but this was a 2017 date of incident, 2018 filing. About a year later, they filed the lawsuit, and the trial was September of 2023. So fairly recently. And the plaintiff did have a safety expert as well. Actually, they had a safety expert, and the defendant had a site safety expert as well. Okay. So that's the fifth case. Let's see what other cases we have here. Here's another case. This one is a case where the date of incident is August of 2016. This was a Bronx case. The date of filing was September of 2016, so just a month later. But the date of trial was August of 2023. So that's like 7 years later. And what happened here was a plaintiff was performing painting, construction, renovation at a premises owned and controlled by the defendant, a general contractor. The plaintiff said he was working on a ladder and fell from the ladder. The plaintiff reportedly suffered a loss of consciousness, a non-displaced fracture of the right wrist, disc herniations at C4 through C7 and L2 through S1, and internal derangement of the left knee. The plaintiff asserted negligence in failing to provide him with a safe place to work, violations of labor law 200, which is the common law, 240, which is the height, gravity-related issue of falling, and 241.6, which has all the codes, the industrial code violations, and violations of Rule 23 of the New York Industrial Code, which, you know, you have to. If you're alleging 241.6, then that's the predicate for that. The way to allege 241.6 is to have one of the industrial code violations. So what do you think the verdict was in this case? The verdict was $1,941,083. And it was broken down as pain and suffering was $941,083. Compensatory future medicals were $1 million. And so the total was $1.9 million. So yeah, that's a pretty good result as well. You know, not bad. Not bad. Almost $2 million. Here's another case. This one is from Westchester. And this one, the date of incident was June of 2016. The date of filing was November of 2018. So they actually waited a while to file. And the date of trial was June of 2023. And like I said, this was Westchester, which was a fairly conservative verdict. Let's see what the case is about. Here you have a 38-year-old who was involved in an accident as a construction worker when a portion of heavy fencing fell on his head, neck, and left shoulder as he walked along a sidewalk adjacent to a construction site owned by the defendant owner, LLC, where defendant excavating was performing demolition work. So the plaintiff allegedly suffered injuries that included a cervical and lumbar herniation and bulges with radiculopathy. That's the radiating pain. Left and right knee medial meniscus tears, a left knee ACL sprain, and left shoulder subacromial impingement with acromyoclavicular joint arthropathy. So, and an anterior capsular contraction, partial thickness tear of the supraspinatus tendon, and an anterior labral flap tear. The plaintiff asserted a claim of premises liability, including causing and allowing a dangerous condition by failing to erect barriers and provide warnings. So what do you think the verdict was in this case? I actually also know the lawyers that handled this case. I think they're pretty good lawyers. The plaintiff called a spine surgeon, and he used an orthopedic surgeon, and he also used an economist. Actually, a good economist. I use that economist as well sometimes. And so what do you think the verdict was? The verdict in this case, it was actually $11,036,539. And it was broken down as follows. It was broken down as compensatory pain and suffering, $3.5 million. Past medicals were $261,000. Future medicals were $5,017,242. Past wages were $351,188. Future wages were $1,906,223. And so the total amount was $11,036,539. So a really good verdict. It doesn't really say, it says what the injuries were, but it doesn't really say if he had surgery. It doesn't really say. I guess it was probably pretty serious injuries with surgery to get those kind of numbers. And he had a strong economic damages case. Like I said, the economist, I usually use that economist as well when I have a case with lost wages. Very good economist. There are actually two of them. One of them is a lady, and one of them is a gentleman who's like older, who's I think about to, or maybe has already retired. And so now they work together. Very good economist. So maybe a lot of it was the economic damages, but you see the pain and suffering damages were very high as well. Okay, let's get into the next case. The next case is upstate a bit. It's Sullivan County, which is like the Catskills. And what happened here was a plaintiff reportedly was hired to perform construction and repair work at a building owned by the defendant, again, an individual, who owned the building for the purpose of collecting residential rent. The plaintiff said he fell from an unsecured and improperly placed ladder, and the plaintiff just suffered injuries. It doesn't really say what kind of injuries. So the plaintiff asserted violation of the Labor Law 240, subsection 1, in failing to provide him proper protection, and the defendant claimed the plaintiff chose the placement of the ladder and placed it on an unstable, snowy ground. And this was a case that happened, the injury happened March 27th of 2019, and the date of filing was September 30th of 2020, and the verdict was May 23rd of 2023. So guess the verdict in this case? It was actually 0, a defense verdict, and that is because, it doesn't really say why, but I'm thinking again, because it was an individual, although this says collecting rent, so it sounds like it wasn't a single family owner-occupied property, so that wouldn't be an exclusion from the labor law. You do have a very conservative venue, upstate New York. Maybe they didn't pick the right jury. You're talking about Sullivan County. And also, if they were saying, look, there was no one else there, he's the one who placed the ladder on the snow, he chose where to place it, maybe they just didn't believe that there was a violation of 240. So probably a situation where the plaintiff should have, I don't know if he did, file a motion for summary judgment, because if he would have gotten summary judgment, then the issue only would have been how much damage, how much money to pay him. That would have been better than letting the whole case go before a jury in a conservative venue where you could lose on liability. You see, so that was probably a mistake, but okay, let's see what else we have here. So that was the 8th case we did. Here's the 9th case, and this one's also in Long Island, out in Suffolk County. And this one was, the date of incident was 2019. The date of filing was 2019, but in December, 2 months after the date of incident, which was in October. And then the verdict was May 1st of 2023. And what you have here is an employee of a demolition company hired by the defendant, general contractor, to perform work at a project site. The plaintiff reportedly was instructed to cut an unsecured steel column. The plaintiff said that while he was cutting the column, it fell onto him. The plaintiff reportedly suffered a crush injury to his leg. The plaintiff asserted negligence of the labor law, 200, 240, 241.6 of the Industrial Code. He claimed the defendant permitted the removal and cutting of an unsecured column when it was not safe to do so, failed to provide proper equipment, failed to provide for the safety of workers, and failed to provide a reasonably safe place to work. The defendant contended the plaintiff was a supervisor for the demolition company and was responsible for safety training at the job site. It claimed that the standard procedure when cutting a beam was to stand on the side of the piece being cut, but the plaintiff chose to stand in front of the beam. It asserted that the plaintiff's decision to stand in front of the beam was the sole proximate cause of the incident. So it's saying basically the same thing. If you're the sole proximate cause of the accident, it means you are the only legal cause of the injury. It's your fault because you stood in front of it. You should have stood on the side of it. And that was their argument. The defendant also claimed that the equipment was available at the job site to secure the beam. And the court granted the plaintiff's motion for summary judgment as to the 240 subsection 1 claim. So they granted him the claim about the height, right, the gravity, because the beam fell onto him. He was cutting this column of an unsecured steel column, and the object fell, on him, so that's gravity related. So they gave him summary judgment on that issue. So guess what the verdict was? It was $1,103,750. And again, this is out in Suffolk County. So you see like smaller verdicts in Suffolk County, $1 million. Seems like $1 million is like kind of like the ceiling out there for a lot of these cases. This one doesn't say how it was broken down. And you see a few of them even get defense verdicts on these cases. So let's see what other case. Let's do one more maybe. We're almost at the 31-minute mark. Let's do one more because we got like this one is, this was Suffolk. Here's another one. This is the 10th most recent. And this one is also Suffolk, which is Long Island and out east. And this one had a 44-year-old plaintiff. He was performing work at a construction site when the defendant was the general contractor when he fell from a makeshift scaffold to the concrete surface below. The plaintiff claimed to suffer a laceration of his left eyelid requiring 14 sutures. And he also had a fourth cranial nerve palsy, radiculopathy at L4S1, spondylosis at L5S1, bulging and herniated lumbar discs, bilateral lumbar foraminal stenosis. That means that it's getting narrow there in the foramen. That's the openings where the nerve roots run. So if it gets narrow, it can compress the nerve roots and cause pain. Lumbar myofascial pain syndrome, head trauma, subjective headache disorder, hearing loss, and nasal and supraorbital fractures. The plaintiff required a lumbar fusion at L4 through S1. So that's L4, L5, and L5S1. That's a 2-level lower back fusion to repair. Okay, so he needed that for the lower back. He also needed surgery to repair the nasal fracture that he had. And he reportedly was unable to return to work. And like I said, he was 44 years old, so a fairly young guy. And he asserted negligence in failing to provide a safe place to work. The defendant argued that the plaintiff was able to perform activities of daily living and return to gainful employment. And so what happens there, if they say, look, maybe you can't return to this job, but you can get another job. So that's where you need to hire a vocational rehabilitation expert to talk about the types of jobs the plaintiff can do and what they can't do. And then the defendant can have their own expert. And then it's like whatever expert is more persuasive to the jury as to whether or not plaintiff can do the job. And so the defendant denied that the plaintiff's claimed lumbar injuries were even related to this accident. The defendant brought a third-party lawsuit seeking indemnification against the plaintiff's employer, which was a drywall company. And the jury, now in this case, the jury rendered a verdict. And so the jury rendered a verdict in favor of the plaintiff on the issue of liability, meaning that the plaintiff was not at fault for this incident, that it was the defendant's fault. And after that, the parties settled. So how much do you think they settled for? The settlement was for $2,900,000. That's a pretty good settlement in Suffolk County. Suffolk County is a tough venue. So those are the 10 most recent cases. Maybe I'll do some other videos. I see there's more cases here, you know, but I'm already at the 35-minute mark. The other cases, you know, just taking a quick look, are also around the same. You know, there's one here for 2.7 million. There's a lot of, you know, maybe I could do another video where I do the next 10 cases, because some of these are interesting. And I see the next 10 cases include Brooklyn, Bronx, a federal court case. Let me see how the federal court case did. Federal court is tough. Oh, 0. Yeah, figures. So yeah, I'll do a video about the next 10 cases, or maybe a video about the highest, you know, the highest verdict cases, so you could see how people are getting the top numbers on these construction cases. Okay, I hope this was helpful. Please like and subscribe to our channel. Let us know what questions you have. If you have a question or need a consultation, just text me, 347-566-9595. We're here for you. Our goal is helping serious injury victims and families. Have a great day, everyone, and we will talk to you very soon. Okay, bye-bye.